Picture this. You're pulled over with a lawfully carried firearm. Your record is spotless. You've complied with every state statute, but within 5 minutes you're standing on a roadside in handcuffs, watching an officer not just search, but systematically tear apart your vehicle's interior. No narcotics, no scent of marijuana, no legitimate legal basis. Your only statement was, "Officer, for safety's sake, I need to inform you I'm legally carrying a firearm." A vast majority of armed citizens remain unaware that a single, seemingly prudent disclosure can cascade into a full-blown, destructive search where officers feel legally shielded to dismantle your property. I'm Jeff Hampton, the people's lawyer, and in this comprehensive breakdown, we're dissecting the reality behind traffic stops while armed. We'll navigate, first, the judicial perspective on detentions, handcuffing, and vehicular searches when you're legally armed. Second, the precise legal moment when an officer can restrain you for safety without formal arrest. Third, the critical methodology to ensure the phrase, "I have a gun," doesn't automatically morph into a blanket search warrant for your car. And stay with me until the conclusion. I will equip you with the exact linguistic formula, the specific sequence of words, designed not only to halt police overreach in its tracks, but to strategically dismantle their qualified immunity, creating a pathway for personal accountability when they violate established law. Our starting point is the true, unfiltered account of an individual who endured the exact scenario described. Our driver, navigating a Connecticut neighborhood later vaguely termed a high-crime area in a police report, was simply operating his vehicle in full compliance with traffic laws while in legal possession of a firearm. Approached the window, the driver, following a principle of transparency, stated, "Officer, I am carrying a firearm, and I'm doing so legally." He presented his driver's license and his state-issued permit. His demeanor was calm. No furtive gestures, no odor of illicit substances, no indicators of impairment. He had committed no wrongdoing. Yet the officer chose escalation over routine procedure. The driver was ordered out, immediately placed in handcuffs, and secured in the back of a patrol cruiser for over 30 minutes. During this prolonged detention, the officer conducted a thorough search of the passenger cabin, glove compartment, center console, and trunk, executed without a warrant, without consent, and absent any criminal evidence. In subsequent proceedings, the officer essentially admitted the search was predicated on the mere knowledge of the firearm's presence. When law enforcement decides to search, it is rarely a delicate inspection. It is often a disruptive process involving ripped upholstery, emptied contents, and broken items, damage for which they accept no fiscal responsibility. They act under the color of law. But does that color paint within constitutional lines? The driver initiated a lawsuit. The case ascended to the United States Court of Appeals for the Second Circuit. The judiciary was confronted with a defining question. Does the Fourth Amendment permit police to handcuff, detain, and search a vehicle based solely on the driver's possession of a lawfully owned firearm, when no additional facts suggest criminal activity? This was the core issue in Sanaa v. Andruski, 2024, and it mirrors the dilemma every responsible gun owner must ponder. Is voluntary disclosure during a traffic stop a safe practice? Officers, trailing him, alleged a minor traffic infraction, a tic-tac issue, and initiated a stop. As they, before applying constitutional doctrine to the case, the court provided a foundational primer on the Fourth Amendment. The Constitution does not prohibit all searches and seizures, only those that are unreasonable. In the traffic stop arena, two distinct legal standards govern police action: reasonable suspicion and probable cause. Reasonable suspicion is a lower threshold, requiring specific, articulable facts that criminal activity may be afoot. It justifies a brief, investigatory detention known as a Terry stop. Within this limited scope, officers may 1. Pose questions. You maintain the right to remain silent. 2. Detain you for a short duration to investigate. And 3. If they reasonably believe you are armed and presently dangerous, conduct a limited pat-down of your outer clothing solely to detect weapons. Herein lies a crucial nuance. Your legal firearm can enter the officer's safety calculus, but it cannot serve as the exclusive factor justifying suspicion. There must be independent facts, separate from the lawful possession of the weapon, that suggest you are engaged in crime and pose a threat. The rule is unequivocal. Being armed where it is legal to be armed is never, by itself, reasonable suspicion of criminal activity. Probable cause is a significantly higher standard. It requires facts and circumstances sufficient to warrant a reasonable person's belief that a crime has been committed and that the person to be arrested committed it. Handcuffing a calm, compliant individual, placing them in a patrol car for an extended period, e.g., over 30 minutes, and executing a comprehensive vehicle search begins to resemble a de facto arrest. Such an intrusion demands probable cause, not mere suspicion. You might interject, "Jeff, I've heard of the automobile exception. Doesn't that allow warrantless car searches?" Indeed, the automobile exception permits a warrantless search of a vehicle if police have probable cause to believe it contains evidence of a crime. However, a lawfully possessed firearm is not evidence of a crime. It is not contraband. Decades of jurisprudence reinforce this principle. Police knowledge of a legal firearm does not, in isolation, justify converting a minor traffic stop into an arrest or a destructive search. That is the established legal framework. What does this framework mean for you on the asphalt? 1. An officer may exercise heightened caution upon learning you're armed. 2. They are legally authorized to take limited, safety-focused steps to secure the situation. 3. They cannot transmute the lawful possession of a firearm into a carte blanche justification for an exploratory fishing expedition through your personal property. Let's apply this to a practical scenario. Imagine you're stopped for a minor speeding violation. The officer approaches and asks, "Any weapons in the car today?" Your legal duty to inform varies by state. Some mandate immediate disclosure, others only upon direct inquiry. For this exercise, assume you choose to disclose. You state, with hands visibly on the wheel, "Officer, before I reach for my license or registration, I want you to know I am legally carrying a firearm. My hands will remain here. How would you like me to proceed?" This communicates you are armed, you are transparent, and you are not a threat. Within this context, what are an officer's legitimate powers? Ordering you out of the vehicle. The Supreme Court, Pennsylvania versus Mims, Maryland versus Wilson, has consistently ruled that during a lawful traffic stop, an officer may order the driver and any passengers out of the vehicle as a precautionary measure. This is a default right for officer safety, not necessarily dependent on additional suspicion. Temporarily securing the firearm. If the officer knows you are armed, courts have affirmed they may ask for the weapon's location, safely disarm you, unload the firearm if appropriate, and retain it for the duration of the stop. This is frustrating and can feel accusatory, but if conducted as a safety measure tied to a lawful stop, it is generally permissible. Performing a limited pat-down, frisk. This is where the line sharpens. An officer may perform a Terry frisk only if they can articulate a reasonable belief that you are dangerous and may gain immediate control of the weapon. This frisk is strictly limited to a pat-down of outer clothing for weapons. It is not a general search for drugs or other contraband. The officer's justification must extend beyond "he had a gun." They must point to specific facts suggesting imminent threat, e.g., aggressive posture, bulges suggesting other weapons, suspicious statements. This is the boundary of acceptable action. Any step beyond this realm risks violating the Fourth Amendment. The pervasive and dangerous misconception, held by some officers and many civilians, is that an armed citizen automatically forfeits their right to be free from unreasonable searches. This is categorically false. Let's return to Sanaa versus Andruski for the judicial rebuttal. The Second Circuit Court of Appeals meticulously highlighted the facts: a calm and compliant driver, a valid firearm permit, voluntary disclosure of the handgun, and a notable absence of any other suspicious factors. Contrasted against these facts were the officer's actions: immediate handcuffing, placement in a locked cruiser for a prolonged period, over 30 minutes, and a full, thorough search of the entire vehicle, including the trunk. The officer's stated rationale: essentially, that the legally owned firearm itself created a justification to search for more contraband. The court's ruling was a powerful affirmation of constitutional rights. A lawfully owned firearm is not contraband. By definition, it cannot serve as the evidentiary basis for a search. The legal carry of a firearm cannot be treated as a suspicious activity. Following the law is not grounds for suspicion. There is no gun exception to the Fourth Amendment. The Constitution does not evaporate at the revelation of a legally possessed weapon. Critically, the court did not merely suppress evidence. It denied the officer qualified immunity, allowing the driver to sue the officer personally for the violation. This is a monumental detail. Qualified immunity shields officials from liability unless they violate clearly established law. By ruling as it did, the Second Circuit signaled that this officer should have known his actions. Treating a legal firearm as probable cause for a full search and arrest-like detention were unconstitutional. What, then, could provide the necessary probable cause for a vehicle search? The firearm itself is insufficient. Additional factors might include the plain-view sighting of illegal drugs or paraphernalia, the distinct odor of illegal marijuana in states where it remains prohibited, observable evidence that the firearm itself is illegal, e.g., an altered serial number, or possession in a jurisdiction where the individual is prohibited, specific intelligence linking the vehicle or occupant to a known crime. Without such independent, articulable factors, a search is an unlawful fishing expedition. Another common but flawed justification is the high crime area designation. Officers often cite this in reports to bolster suspicion. However, the Supreme Court has warned that an individual's presence in a high crime area, without more, is not enough for reasonable suspicion. Illinois versus Wardlow provides nuance, but does not negate this core principle. Therefore, lawfully carrying a firearm while driving through a statistically high crime neighborhood does not, by itself, create reasonable suspicion or probable cause. Now, we must dismantle pervasive and hazardous pieces of common sense advice that routinely leads citizens to waive their rights. Bad advice number 1. If you have nothing to hide, just let them search. The Fourth Amendment is not a privilege for the guilty. It is a fundamental right of the innocent. Consent irrevocably waives your protection. Bad advice number 2. If you're polite and cooperative, they'll be nice and let you go. Politeness is crucial, but cooperation can be misconstrued as implied consent. An officer may later testify, "He was very cooperative and didn't object when I started looking," framing the search as consensual. Bad advice number 3. If you have a gun, they're going to search anyway, so don't fight it. Sanaa versus Andruski and other cases prove this is legally untrue. Asserting your rights creates a vital legal record. Acquiescing normalizes unconstitutional behavior. I learned this lesson painfully years ago with my own classic car. A consensual search led to a ripped interior and shattered trim, with zero recourse. Consent is a one-way door. So, what is the practical protocol? From the moment you see emergency lights, signal and pull over safely to a well-lit, public area if possible. Place your car in park, roll down your driver's side window, turn off your ignition/radio, and turn on your interior dome light if it's dark. Keep both hands clearly visible on the steering wheel. Do not reach for your license, registration, or glove compartment until instructed. If you are in a duty-to-inform state or choose to disclose, use a clear, non-confrontational script. "Officer, before I reach for anything, I want you to know I am legally carrying a firearm. My hands will stay right here on the wheel. How would you like me to proceed?" If the officer begins to escalate, orders you out, secures your firearm, comply calmly with the commands. Do not physically resist or argue on the roadside. Your behavior is being documented. Calm compliance, as seen in Sanaa, later undermines an officer's claim that you are dangerous or uncooperative. The critical juncture often arises after the initial safety steps. The officer may use seemingly casual language to seek consent. "You don't mind if I take a quick look in your car, do you?" Or, "Why don't you pop the trunk for me?" These are not commands. They are requests for you to waive your Fourth Amendment rights. The overwhelming majority of people say yes due to anxiety, a desire to be perceived as helpful, or simple uncertainty. You always have the right to refuse consent to a search, regardless of what an officer implies. Your refusal cannot legally prolong your detention or be used as probable cause. U.S. v. Gross. If the officer insists or claims a right to search based on the firearm, your role is not to debate constitutional law at the roadside. Arguing, but in the Second Circuit they ruled, will likely inflame the situation. Your objectives are to clearly and unequivocally refuse consent for the search, to determine if you're being detained beyond the scope of the original stop, to cease providing any information that could be misconstrued as providing probable cause. Here is the 4-step script for an escalating encounter. Step 1. The initial disclosure, if required or chosen. Officer, before I reach for my documentation, I need to inform you that I am in legal possession of a firearm. My hands will remain on the steering wheel. Please instruct me on how you would like me to proceed. Step 2. Compliance with safety commands. If ordered out, respond with yes, sir/ma'am. Step out calmly. If disarmed or subjected to a pat-down, do not resist physically or verbally argue about the necessity at that moment. Your calm demeanor is a strategic asset for any subsequent legal challenge. Step 3. The refusal of consent. When the officer requests or suggests a search, respond immediately and clearly. Officer, I do not consent to any searches of my vehicle or my person. I also decline to answer any further questions without my attorney present. Say this once clearly, then stop speaking. Step 4. Establishing the record. If the officer proceeds despite your refusal, or your detention seems excessively prolonged, you need to create a clear legal record. Ask, Officer, for clarity, am I being detained, or am I free to go? If the answer is unclear or you are detained, follow with, I want to be clear for the record that I do not consent to any searches. If you're ultimately arrested, state, I am invoking my right to remain silent and my right to an attorney. I will not answer any questions without my lawyer. This script does not guarantee the officer will comply with the law. Some may proceed unlawfully, as in Sanaa. However, this script does guarantee that you have not waived your rights. You have created a contemporaneous record of your non-consent and invocation of rights, and you have preserved the strongest possible civil claim should your rights be violated. It strategically positions you to destroy their qualified immunity by demonstrating the officer acted against your clearly stated constitutional objections in a context where the law was clearly established. In conclusion, the Sanaa versus Andruski ruling is a potent reminder. The legal system, when properly invoked, can hold authority accountable. The court affirmed that a legal firearm is not a waiver of the Fourth Amendment, that detention beyond a brief safety check requires more, and that officers who ignore these principles face personal liability. Your power lies in knowledge and precise action. Know the difference between a lawful safety procedure and an unlawful search. Understand that consent is the master key you control. Use the script not as a weapon for confrontation, but as a shield of clarity and a recorder of truth. The goal is not to win an argument on the shoulder of the highway, but to ensure that if the law is broken, you have the tools to win where it ultimately matters, in a court of law. Your rights are not requests. They're the bedrock of your liberty. Carry responsibly, know them thoroughly, and assert them strategically.